Hello. My research project at the University of Milan Bicocca is entitled Understanding Conscientious Objection. This may sound simple, but in fact it is far from simple. Conscientious objection is typically discussed as an individual refusal, motivated by conscience or religion, to comply with legislation of general applicability. In legal terms, conscientious objection should be understood not just as an expression of a deep moral conflict, but as a claim for conscientious exemption, an exemption from a general obligation imposed by law. This legal dimension is a relatively new phenomenon because as recently as a few decades ago, the need to afford legal protection to such claims was anything but obvious. The general aim of my research here is to work on a conceptual framework for a better understanding whether and how the conscience-based claims should be accommodated by public law. And just to give you an idea how complicated this immediately gets, here's a handful of questions. The European Court of Human Rights believes that in order for conscientious objection to be recognized, in order to count as a manifestation of religion within the meaning of Article 9 of the European Convention, the act in question must be intimately linked to the religion or belief, and that there needs to be a sufficiently close and direct nexus between the act and the underlying belief. How can this be measured and demonstrated before the court? When does that link become too thin or loose? And to make this question more specific, does anyone become actually involved in moral wrongdoing by simply serving another person or helping that person do what they would never do themselves? This is what happens when, for example, a Catholic doctor is supposed to refer the patient to another doctor who is ready to perform abortion services. Can a religiously neutral state expect that? Or should this mere referral be covered by the right to conscientious objection? Let's go further. Should we make any value judgment when recognizing conscientious objection? Or, as the debate goes, do we recognize conscientious objection out of respect or tolerance, or perhaps both? What are the consequences? What if the number of people objecting on grounds of conscience is so high that it makes a given service inaccessible to those who need it and who seek it? This is what happens to abortion in some regions of Europe. But is it only about accessibility? What about discrimination and expressive harm? How to safeguard the right to hold and express critical opinions based on religious beliefs about other people, while at the same time not discriminating against them? If a same-sex couple is denied service in a restaurant because the owner of the restaurant believes that their conduct is sinful and unacceptable, is it really okay as long as there is another restaurant in town? Or is the real problem here, as many believe, the discrimination and humiliation of that couple got turned away? And to add an even more recent perspective, the vaccination. Would the European Court of Human Rights ever recognize the right to conscientious objection to compulsory vaccination? These are just a few questions that my research here is about. The debate over conscientious objection has been going on for some time now, and a lot of work on the topic has been published, but there are still so many questions to answer.